Thank you everybody for joining us for this month's edition of African Liberty webinar. My name, as usual, is Ibrahim Babatunde Anoba, Managing Editor at African Liberty. This month we are talking about something very, not only interesting, but crucially interesting as well, more so as we consider the future of rule of law and justice on the continent. So the topic for this month is Judicial Independence and Access to Justice in Africa. And we have with us three fantastic individuals to help us understand why this question is important at this time. We have Prof. Oxtoby, who is a South African legal consultant, an independent legal consultant specializing in judicial appointments and conduct, constitutionalism, the rule of law, and public international law. He has contributed to projects such as the development of the Lilongwe Principles and the Guidelines, on the selection and appointment of judicial officers and monitoring the South African Judicial Service Commission's activities. Welcome, Chris. And also we have with us Professor Gabriel Arishe, who is a professor at the University of Benin in Nigeria, specializing in constitutional law and comparative constitutional law. He supervises doctoral students and conducts research on African legislatures with a notable publication titled Developing Effective Legislature. Professor Arishe co-authors annual reviews on Nigerian constitutional development for both the Global Review of Constitutional Law and the International Review of Constitutional Reform. Welcome, Prof.
Thank you. Thank you.
Sure. And we should also have with us, as time goes by, Dr. Beatrice, who has been awarded an honorary Doctor of Law by St. Xavier University in Canada. She is also the current board chairperson of the Zimbabwean Lawyers for Human Rights. So hopefully she joins us as we proceed. But we have capable hands at this point. And before we came on, I was looking at the most recent Human Freedom Index. I think it's published by the Cato Institute and the Fraser Institute in Canada. And I was looking at the countries, the rankings, and this rankings pretty much looks at a varied amount of factors: rule of law, periodic election, the power of the constitution, the independence of the judiciary, press freedom, among others. And the least ranked countries in that, on that index, majority of them are in sub-Saharan Africa. As a matter of fact, out of the 10 regions of the world, sub-Saharan Africa was like number 8. So, which is quite interesting and concerning too. So I wonder why, and this, you agree with me, this ranking hasn't really changed across the years. We've seen the same problem for decades. So the question many people want to ask is, why, as African countries, continue to rank low on anything that has to do with human freedom or judicial freedom? Why are we seeing more judicial problem in sub-Saharan African countries in comparative terms with the rest of the world? Quick introduction. I want to start with you, Professor Arishe, then we go to Chris.
Thank you, Ibrahim, for that question. Africa continues to rank low on the major indices of democracy across the world because of one thing: personal rule. Government is still a personal entitlement of one person or of a family. If you look at the concept of democracy and even governance by itself, it should be a system that has institutions governing. Government should be an institution, not a person, not what one person likes. If we go back to all the principles and theories that were propounded in the past, begin from John Locke, on and on to anybody you can talk about. Institutions should govern. Okay, let's begin from John Locke, for example. His major thesis is that man decided to form a political society and then decided to have a government over him, and that government should be the institution through which he relates with a fellow man, and that government should be so powerful that it can protect him and protect his fellow citizens. That is the whole essence of social contract. But in Africa, that is not what we have. We still have the big man who dominates, who is above the law, who dictates what goes on, and so on. And so the Constitution is under him. This Constitution is not supreme. Take the ease with which the Constitution is amended to allow one man to rule for very many years. In all these African countries where you have one person ruling for decades, I tell you there are term limits. But the Constitution is easily amended by the legislature with an overwhelming majority, permitting one man to rule ad infinitum until death removes him from that office. And so personal rule is a major thing. And once you have personal rule and not institutions governing, then every other thing will be subjected to the whims and caprices of that man. So talk of freedom of the press, human rights, in fact, the whole civil liberty as a whole will be under him. Civil liberties will be as dictated or as allowed by him. Personal rule is a major thing. And once you bring up personal rule, then you know that institutions of state are weak. There are no checks. There are no constraints on power. The Constitution is subdued by that one man, and then it affects every other thing in the state. And then, of course, the electoral system cannot be transparent, because where you have personal rules, something follows: electoral authoritarianism, where the ruling party continues to win elections because of a compromised electoral system. I mean, so the problem is simply personal rule. The day we agree to democratize, when leaders agree to subject themselves to the rules and to the law, we'll begin to get it right. Thank you.
Nice start, Prof. So, Chris, what Prof just said makes me remember the recent elections we've had in Africa, from I think DR Congo to Uganda to Sierra Leone to Egypt to Zimbabwe. Across board, there were situations where the ruling party or the president pretty much manipulated the constitution or the electoral commission to win elections. And this speaks directly to what Professor Arishe is saying regarding one man having the power to pretty much dictate what the judiciary should look like, more so the constitution. But why do you think this has continued to be the case, Chris? We've tried different legal reforms across different countries, more constitutional amendments, expanding the legislature and whatnot. But why does this persist, more so in sub-Saharan Africa, please?
Well, thank you. I mean, that's a complicated question that I think defies a single simple answer. But the one thought that's been coming into my head as I've been listening to the beginnings of this discussion is a question of culture, a question of legal and political culture. Do we have systems and societies where people are able to speak up for, advocate for, protect the courts, protect judicial independence, advocate for the rule of law? I'm not sure that we do, generally speaking. And that may be due to a wide range of factors. But I think it's also very much something that gets exploited by unscrupulous politicians in many cases. Some may not know any better, but I think some are very much alive to what they are doing, and try to do their best to paint the court, or the courts, I should say, as a problem, as an impediment to good governance. And this is something that's been in the news recently in Kenya. It's a tightrope that South Africa always seems to be walking on. I mean, it's a particular dynamic that we have, which may not be typical of other countries in the region, but where we have a constitution that gives very expansive powers to the courts, and therefore often pulls them into highly politically contested areas. And I think the court enjoys a certain level of sort of public support, and there's a certain level of a culture of understanding that what the court does and why it's important. But I think even in our case, that's quite tenuous, and I suspect that in many other jurisdictions, it's even more tenuous. I don't know if we think across both for regular citizens and for political elites. Do we have a clear understanding of what the role of an independent judiciary upholding the rule of law actually is? And are we, particularly in the case of politicians, prepared to sacrifice short-term self-interest in order to ensure that the institution of the judiciary continues to do that work? And I fear what tends to happen far more often is that the judiciary becomes an easy scapegoat to be bashed when there are political challenges or political problems, and the politicians need to deflect attention away perhaps from their own shortcomings, and then it gets blamed on the courts. So, and I do think the point is linked to what Prof was talking about earlier, and it very probably the lack of a culture of upholding the rule of law, upholding judicial independence, probably in large part does stem from strongman culture and so on. But I do think without that ingrained culture across our political life, across our civic life generally, it does make it very difficult to see how we are going to, in the long term, establish the kind of strong, independent judicial systems that we would like to see.
Right. So on the same issues, I at some point I wanted to be a lawyer, but one of the questions I couldn't understand is why, I mean, you guys have sort of help us understand that there seems to be a problem between in the way the executive relates with the judiciary, more so the constitution and judges. If that's a problem, then why do we allow executives to appoint the judiciary in many African countries? I mean, I don't know if South Africa or Nigeria is different, but in many African countries, the president is oftentimes the one that appoints the chief justice. That's one. But also number two, in many African countries, when there are legislative reviews or bills being introduced or constitutional review, oftentimes, I hope I'm correct, we'll have the president sanction or veto in some way any bill. So if that's the case, how on earth are we expecting the relationship between the executive and the judiciary to be any different than what it is? Prof, is this wrong or what's going on?
Okay. Thank you, Ibrahim. Yeah, I would just say a few things before I go to the question you just asked. Why does the strong man persist in African politics? The reasons are clear. Number one, you have a small middle class that can challenge the status quo. That's a major problem. Very few people think that they have a stake in government. Maybe because we have oil money, we have resources, we have gold, we have all sorts, so we are not paying taxes. If we feel we have a stake in government, then we'll be ready to challenge the wrongdoing and even challenge the strong man. Then another thing is a subdued civil society. Of course, when the middle class is small, the populace is pauperized by the strong man, and then you're going to have a subdued civil society that really cannot stand up to challenge the strong man. And then the third reason is patriarchy. You have a system of, the strong man is an elder in the society. So it's un-African to challenge an elder. You don't say an elder is wrong or is lying. I'm sure in some countries you hear that the president is addressed as the father of the nation, and his wife is the mother of the nation. So how dare you challenge the father or the mother of the nation. It's a problem. It affects the political system. And then lastly, corruption. That's the big one. I mean, in Africa's presidentialism, the resources that are available to the president are so enormous that he can buy just anybody who is available to be bought. It's a major problem. Okay, now we amend the constitution, and then we still have this problem of saying the president must appoint. Yeah, in Nigeria, in my country, for the federal judiciary, the president appoints the justices of the Supreme Court and the Chief Justice of Nigeria, subject to the approval or ratification of the Senate of the National Assembly. But that is not the case for other judges. For the Court of Appeal and for the Federal High Court judges, you don't require approval except for the head of those courts. And so once the president appoints, so be it. Even though, yes, we have the National Judicial Council that makes recommendations to the president and so on. But again, how independent is that body? It's a major problem. Now, we try to amend the constitution, but the same judiciary in Nigeria, take Nigeria, for example, has assigned a gatekeeping role to the president. In 2010, the National Assembly amended the constitution in the year 2010, and then insisted that the amendment automatically altered the constitution. The president refused. He said, no, that was not the case, and the matter went to court. And the judiciary said, well, the same procedure for passing an ordinary legislation, which is the use of a bill, is the same procedure you use for the constitution, even though it requires a higher threshold of voting by the National Assembly, 2/3 or 4/5, as the case may be. But insofar as the instrument uses a bill, the constitutional stipulation that a bill passed must get the assent of the president should apply to the constitution, to the alteration of the constitution. So from then on, the president has the right to say, look, I'm going to give assent to this. I'm not going to sign this. So who do you blame for that? So sometimes you find that the president's enormous power has so affected other players, those in the legislature and the judiciary, that the fear of contradicting the president, perhaps, in quote, is the beginning of wisdom. That's what we find in Africa. Quite unfortunately, it is so. So African institutions, the legislature, the judiciary, lack the independence, sometimes self-imposed, that will make them challenge presidential power. It's a big problem. You try to amend the constitution, and yet you cannot whittle down the power of the president. Let me give you just one example before I leave the floor for other members to contribute. The constitution went through an alteration before President Buhari left office. 44 alterations were sent to him. He gave assent to 16. I mean, if you know the process in Nigeria, from the Houses of Assembly, at least 2/3 of the 36 houses must support before it goes to the National Assembly, who must vote with a higher threshold. And at the end of the day, just one man will say, no, I'm not going to give assent to this. Now, before the National Assembly, the 9th National Assembly was dissolved, President Bola Tinubu took oath of office on the 9th of May. And then he gave assent to one of the alterations rejected by President Buhari, which is the alteration harmonizing the retirement age for all the judges. Before now, the judges of the Court of Appeal and the Supreme Court retired at 70, and then High Court judges retired at 65. Now, just a bill said, look, once you are a judge subject to good health, you can retire at 70. President Buhari rejected that until Tinubu came and gave assent to that. I mean, for whatever reasons, we don't know yet. All right? So why is it that this system continues? It is because perhaps we don't have men of courage in the other branches.
Right. Interesting. So before I go to the next question to Chris, I want to remind our audience to to participate by asking questions. So you can drop your question in the Q&A function or the box right there, or you can just drop it in the chat, but preferably in the Q&A. I'll be sure to answer your questions. Otherwise, you can raise your hand and we can bring you onto the floor and ask a question quickly. So, Chris, we know that the judiciary nowadays is not limitedly defined or constrained to the courtroom. In some cases, the electoral body or the electoral commission have the power to have judicial functions, more so after elections, or there are disputes in what we call election tribunals. Those are oftentimes held with the power of the electoral commission. The electoral commission has a great role to play in that. You have an election currently ongoing in South Africa, and there have been questions about the power of the electoral commission in the country. I wonder how you see electoral commissions generally across the continent being able to apply the law any differently from the judiciary, or are they the same? Are they having the same shortcomings as the judiciary? Because if not, why are we then seeing calls that elections have been rigged or the electoral commission has been corrupt?
Yeah, thanks. It's an extremely topical question for those of us in South Africa, as you say, where we have votes being counted by the Electoral Commission as we speak. I'm going to have to address that specifically in the South African context, because I'm not very familiar with the extent to which powers of electoral commissions in other countries may differ from ours. So in our system, the Electoral Commission is the fundamental body that runs the election. So they're responsible for the organizing of, the voting day, for the counting, for at a basic level, dealing with complaints and objections to candidates. And I mean, very famously, some of you may know, just recently we've had an issue where our former president, Jacob Zuma, is standing or attempted to stand for a party that is essentially a splinter from the governing party. He attempted to stand for that, and there was an objection and subsequent litigation because he has been previously convicted of a criminal offence for contempt of court as a result of failing to appear before a commission of inquiry. And there was a debate over whether this brought him within provisions of our constitution which prohibit him from standing for parliament. So just the architecture of how that played out is helpful to understand the different roles of the Electoral Commission in relation to the judiciary. So the Electoral Commission receives this objection. They then rule on it. In this case, they found that the objection was good and that Mr. Zuma was not eligible to stand. He and his party then challenged that. That decision goes to a specialist electoral court. So that's a regular court, also not a regular court, but it's part of the regular court system, sits on an ad hoc basis to deal with electoral challenges. The electoral court found that, in fact, he was eligible, but our constitutional court, just a week or so before the election, overruled that and said that, no, he was indeed not eligible to stand for parliament. So the Electoral Commission in this case, I wouldn't really describe it as a judicial role. It's an administrative body, really, and it's obviously then bound by the legislation that it has to implement. It's bound by administrative law standards, but there are then levels of the regular court above that, where challenges and decisions can be dealt with. That by and large for us has worked quite well, and the Electoral Commission has generally, I think, been seen as quite a credible and trusted organization. I mean, I would say one thing that is very relevant to our experience in these last elections, and that this goes to some of the challenges that you've alluded to in the question, and that is the question of resourcing. And I think this is the issue of resources and funding, I think, underpins so many of the institutional challenges that we're talking about in this conversation. And our Electoral Commission had quite a significant budget cut, with the result that certainly my experience of these elections, they were the most difficult elections that we've had to vote in my time of voting, and that seems to be true for many people. We had tremendously long delays, and there is now a bit of a blame shifting exercise with National Treasury saying, no, well, the Electoral Commission said they'd be fine and they could do it with this budget. The Electoral Commission saying, well, you didn't give us enough budget. Who exactly to blame is to blame, I don't know. But I think this does point to an important underlying issue that none of these kind of institutions that we're talking about here are going to really be able to properly fulfill the kind of roles that we want them to do if they're not adequately resourced to do the job. And that resourcing can obviously happen at a great many levels. It can happen in terms of just having the right number of staffing in place. It can happen in terms of physical resources available to you. But if we're not willing to fund these organizations properly, we're going to start having problems with them. And of course, the problem is that unscrupulous leaders know that and very often use underfunding as a deliberate way to neuter organizations that we need to protect the rule of law.
Exactly, which again goes to the whole problem of this big man or big men having the power to determine to the extent to which the judiciary, and in this case, the Electoral Commission, is independent or reliant. Okay, so we do have some questions. Professor Arishe, are you there? These questions might be more appropriate for you. From, I think, Blink Irisa, they want to know how to challenge elders when there is no right to express our opinion, when you cannot lead the manifestation or say no in decisions. But anyway, I think they are pretty much asking about your elderly men argument and how we can challenge that.
Yes, you don't wait to be given the authority to fight for your right. If you believe this is what should be done, then go ahead and fight for it. Remember, no authoritarian leader will give you the authority to challenge you. No authoritarian leader will do that. I'm not preaching revolution here. I'm not preaching revolution. But no constitution says, please, when you are tired, when you are fed up, you can revolt against this constitution. It's not written anywhere. Every constitution, including the authoritarian constitution, will tell you they are supreme and you cannot challenge them. The middle class must rise up and fight against what is wrong. We must insist on electoral transparency. We must insist on judicial independence. It will not happen one day. It will not happen one day. But we have to keep on striving. One day we'll get it right.
Right. Well, thanks for that, Prof. So I think one of you briefly mentioned the role of the civil society, and we work in the civil society, and of course we cannot shy away from taking many of the blame. But before I proceed, Ahmed, do you have a question? You want to go ahead and ask a question, Ahmed Abdi? Are you there? All right, we just proceed. So the civil society, you want to go ahead now, Ahmed? Your microphone is muted. Please go ahead and ask your question briefly. Your microphone is muted. Okay, well, we'll just proceed. Now, the question about civil society, we know that in many democracies that are, we want to call them stronger. I don't even know if there's any if any democracy is strong nowadays, because you look at the bastion of democracy, the US seems to be having all this problem with the judiciary, and they can't even trust anybody now. But we know that in proper systems, the civil society has a significant role to play. But I want to know, do you think the civil society in Africa is doing enough? And if not, what do you think are the pitfalls or the shortcomings currently, and how they could be addressed? I'll get the opinion of each of you, since you are much more of an expert in West Africa and South Africa, respectively. So go ahead, Professor Arishe.
the civil society did better before independence and immediately after independence. Before independence, well, we had nationalists who, unfortunately, upon taking over from the colonialists, repeated the same mistakes, the same oppression. We later saw it, quite unfortunately. Then the civil society immediately after independence was also strong. Take the press, for example. The press, they did better. But today, the civil society organizations are facing a lot of challenges. Number one, you talk of the support of young people. The priorities of young people seem to be different today. I'll give you one example, and I mentioned it to my students in class. A research was done in Nigeria some time ago, and the finding was that before independence, when the population of Nigeria was smaller, way smaller, and when the level of education was not as we have it today, and when the newspapers in Nigeria, the print media, the newspapers were fewer, that Daily Times alone sold 400,000 copies daily, Daily Times as a news outfit. But today, we have more publishing houses, the population is higher, education is more. All the newspapers sold in Nigeria per day, all of them put together, are not up to 100,000 copies daily per day in a population of over 200 million people, where majority are young people. Now, the young people are more interested in fun, music, play, and so on. So if these are not disturbed, they don't find any problem with the government. If you allow them to play their music, to do what they like, and so on, they really don't see anything wrong in that government. So when we talk of securing the future, economic development, civil liberties, they seem not to appreciate this a lot. Now, these are the people who are to push the agenda for development. And I dare say the people who are to support civil society organizations more. They have the strength, they have the agility and everything, but their priorities are quite different. It's a major problem that civil society have. And then you also have the issue of corruption. The politicians are smarter. They also register civil society organizations in support of their political agenda. So you find the youth, supporting persons rather than ideologies. It's very common. And then another aspect of corruption is, set up an NGO to make money. I mean, once that is the main objective, you have a lot of problem. Okay, remember what I said, that we have a small middle class which has reduced the number of people who believe that they have a stake in government. That is it. You have them, but many don't care. Take our voting pattern. Nigeria has a population of over 200 million people. But when you do the presidential election, you'll be talking of 27 million votes put together. I mean, total vote cast, including invalid votes, 27 million. Where are the other over 150 million people? It's a problem.
Right.
So support is a problem. Yeah, thank you.
Yeah, I mean, we can talk on and on about how, we don't have sufficient public participation in civil society. But where civil society seems to be perhaps the strongest in Africa is in Southern Africa region, more so in South Africa. But before I come to you, Chris, I think we have some comments here by Ernest Magawane, they say when the president of the High Court in the country works under the guidance of the president of the country, are you sure that the president will respect the rule of law and the justice for all? Sometimes he or she is influenced by the president in his or her decisions. I think Prof already touched on that. There is a comment from Blink Irisa or Abdis Sattar Ali. They say, what are the biggest pillars that hinder Africa from having one goal and leave the agency of? Okay, I can't get that question. But in any case, Chris, the civil society in South Africa is very powerful. It's stronger, in my opinion, compared to vast majority of the continent. I was there last year in relation to some civil society work, and I could testify to that. But I think amid that strength, I don't think we've seen sufficient volume or criticism coming from civil society regarding the excesses of, say, for example, with the Zuma administration or the Ramaphosa administration's shortcomings, or maybe the shortcomings of TESCOM or ESCOM and many other national agencies. So in your opinion, do you think having strong civil society is more so about numbers or getting support from the public or having proper funding or being independent? Because I think we've seen that in South Africa, but it doesn't really translate into the society being vocal. What do you think is the problem?
Yeah, so I mean, I think it's a fair assessment of civil society in our country, that it is a very active and engaged and quite influential group. I think there's a couple of contextual factors to that. The first relates to the certainly as far as civil society that is working in the legal or the quasi-legal space, and that is that the South African Constitution does give a very helpful enabling environment for civil society organizations that want to go to court. And we've had a fascinating range of famous court challenges that have really made a very significant impact on our constitutional law that have been driven by civil society organizations. And that's helped by factors like our constitution introducing very extensive standing rules, which allows NGOs to have standing to bring cases that they would not have had pre the constitution. So although we did have pockets of quite active civil society resistance during the apartheid era, it was certainly nothing like on the scale that we have now. So I think that's a really important factor, and it's coupled to the fact that for all the many shortcomings in our politics and our governing parties and so on, there has broadly been a respect for the independence of civil society and the power of civil society to advocate, to litigate against government. And I suspect that is something that may not be true of other jurisdictions. And I think it is, as I was speaking about political culture earlier, I think that's a positive of our political culture. You do occasionally get some politicians grumbling about NGOs who are funded to pursue a particular agenda and so forth. That kind of narrative is there, but it doesn't, I would say, have a particular impact on NGOs' abilities to do this kind of work. So I think point one, that enabling environment is tremendously important and maybe if not unique, but maybe quite unusual for South Africa. And I think you've alluded to another really important aspect, which is funding. And I can't speak to the donor situation right across the continent, but I think it certainly is true that there are countries where civil society activity is better funded than others, and that's obviously going to make quite a difference to how much you can do. And as I say, I think just going back to the cultural point, I think our history does help us. We did, although, as I say, during the apartheid era, civil society was obviously more restricted in how much it could do, but there was quite a history of opposition to the regime from within civil society, whether it was from trade unions, whether it was from organizations campaigning for, rights of detainees or against military conscription and so forth. It did give us a culture to build on when we then got these democratic freedoms under our constitution. We were not starting from a blank slate. So I think that makes quite a difference as well. So if you're in a country which doesn't have a strong history and a background of civic activism, where that kind of thing has been repressed and not permitted, I think it's inevitably going to take a while, and it's going to be quite a slow and incremental process to build that up. I think South Africa's got a happy combination of circumstances which make it a bit easier for us to be that active and that engaged. Our civil society is a pretty lively and boisterous group, I must say. But to what extent that is capable of being exported into other jurisdictions, I'm not sure. I know it's something in the course of my work when we've engaged with organizations from other countries, we have been quite conscious that they are not operating in the same kind of environment that we are. So although we might look like something to aspire to, I'm not sure how easily our experience will translate into a different context.
Right. Thank you, Chris. So, Professor Arishe, I don't know if you're there. You recently answered a question by one of our Ghanaian attendees. You want to touch on that real quick before I ask you the next question?
Okay. Can you is it a question on public comments in courts?
Yes.
I think that yes. If a case is pending in court, ordinarily by the rules of court, there should be no public analysis of such a case, because we think that may not be proper. In law, we say that such a case is sub judice, is a Latin word, meaning that don't comment on cases pending before the court. Now, even if there is a public analysis of such a case, it may not affect the outcome, depending on two things. Number one, the judges involved, going by their antecedents. There are judges who are very courageous, who know the law, who will stand by what the law says at any point in time. So they are not moved by public sentiment. The second one, and most importantly, is judicial precedent. Is there a principle, an existing principle of law on that matter that was decided in a previous case? Most likely, the judges are going to follow that same principle, except there are compelling reasons why they should depart from the existing principle. So public analysis of cases that are pending before courts, it's not a good idea. It may not help judicial independence. But where people have lost faith in the judiciary, you'll find a situation where people make public comments on cases, particularly political cases, election petition. I'll give you an example with Nigeria. When the presidential election petition was before the tribunal last year, billboards were made with the bold inscription, "All eyes on the judiciary." Well, people didn't say what the court should decide, what the outcome should be, but somehow there was a subtle pressure on the court to decide the matter one way. But at the end of the day, the matter was decided in a way that the public really didn't like. But in all, if we are to follow legal principles, matters pending before the court should not be subject of public analysis.
Okay, that's well taken. So the next question I want to ask both of you before we go back to the Q&A, which I think Chris already kind of touched on, is the role of, should I say, foreign actors in the judiciary in Africa. We cannot deny that many of the bills we've seen recently on the continent, or the changes in terms of removing judges and whatnot, or adjustment to the Supreme Court or High Court, whichever the case may be, have been as a consequence of foreign policy. Certain African leaders trying to adhere or satisfy some partners across the world. So first, Chris, I don't even want to localize it to South Africa at this point, but what do you make of the role of foreign actors in the judiciary in Africa? Do you think it's overplayed, or is it not talked about enough? Or are we just overblowing it? It's not that strong. It's not as crazy as a military intervention or political intervention. The judiciary is not being free traded. Is that the case?
Yeah, look, I'll share my perspective, which may be different for others from other parts of the continent. I would say in the sort of broadly in the SADC region, or certainly in and around South Africa, it's not a question that has really. It's not a particularly live topical issue that is seen as a problem in our context. I mean, of course, you're going to have some level of interaction and engagement around things like judicial training. I think it can present this sort of concern about being careful about being perceived to be influenced by foreign actors can spin around both ways. And I know I'm aware of instances where judiciaries have been very wary to engage in training programs, which they need, but they're quite cautious about getting involved with it because there may be donor funding involved, and there's the concern that there'll be a perception of foreign influence in there in some way. But I'm struggling, I must say, off the top of my head, to think of any instances where we, on our part of the continent, have had concerns about judicial decision making being improperly influenced or being, directed to further ends of foreign powers. Of course, I mean, it goes without saying that the court's duty is to apply their law and their constitution, and be independent and true to that law. And judicial decisions that are furthering other agendas, whatever those might be, are not what the courts should be there to do. And that sounds quite idealistic. I think it's also important that we don't lose sight of that fundamental truth.
Thank you. Okay, so rather than ask you that question again, Professor Arishe, I'd rather ask you this question from Rodney Ellen, because this is a question that not only lawyers have reckoned with, historians have also reckoned with this to a greater extent. So I think they're asking from Uganda, given the dialectics between the traditional judicial system and civil judicial system, to what extent can we say the laws are in conflict with customs? I guess the way we can frame it is, what is the place of African customary law or customs in this new so-called modern 21st century judicial framework across the continent? And is that in any way contributing to the human rights problem we're having or not?
Yeah. It does. It does. I will answer it from two angles. First of all, when we had, in fact, before we had independence, the colonialists filtered African customs in order to accept some as customary law. So in other words, not all customs were accepted as law. And what the colonialists told us was that for your custom to be accepted as law, it must not be contrary to public policy. It must not be against good conscience. It must not be against natural justice. And some persons asked, whose conscience? If you say it shouldn't be against good conscience, is it the conscience of the African or the conscience of the non-African? I'll give you a typical example. A long time ago, we know, you can marry more than one wife in Africa. But we had a law of bigamy. If you are legally married to one woman, you can't take another one while that marriage is subsisting. For very many years in my country, we couldn't convict anybody for such an offense because you ask the judge himself, does he have one wife? So on. Now, that is one example. Now, we have a situation where certain norms or practices are becoming popular in the West. And they're finding there's an attempt by international pressure to push them to Africa. And you have some African countries say no, like Uganda, like Ghana, say no. By our laws, by our custom, we cannot accept this. And that is bringing friction. It's a problem. Now, how does that affect judicial independence? Where your laws do not support certain practices that the international community says you must support, there will be subtle pressure on your government. Of course, there are threats. You won't get loans, you will withdraw aids, and so on. By and large, there will be subtle pressure against you, and sometimes visa ban against MPs, and by extension, judges who dare decide in favor of the laws passed by parliamentarians. Now, that may put judges under pressure. You know, what a judge must enjoy is personal independence. Yeah, he should enjoy substantive independence, but a judge must enjoy personal independence so that he's not under pressure to decide a case one way because he fears for his safety or because he fears that he will be deprived of a privilege or a benefit. So that affects us. So can custom run side by side with English law that we have? It can, even though we say that there are certain customs that we will not allow because our law says they are contrary to public policy. Yeah, there's nothing wrong with that. If you say these laws are contrary to public policy, so we should not allow them. But again, we should be allowed to say, look, this international practice is contrary to our custom, and we should be respected for that.
Right. Okay. Well, that's interesting. So we're running out of time, and I think Yango Barikako have a question about the father figure, as you mentioned, the Prof, and also a comment regarding why people are going to TikTok rather than reading newspapers. But anyway, we run out of time. Chris, do you have a closing observation to make regarding the state of judiciary across the continent?
Yeah, thanks. Look, I think it's clear that we face a great many challenges, and we are some way away from where we would like to be. I think I've touched on the question of the sort of social and political culture in which the judiciary operates, which I think is often an impediment. I would just, I guess, finally come back to sort of my holy triumvirate of aspects that I think are really crucial to underpinning judicial independence and the rule of law. That is, we have to have a strong appointment system. We have to have a strong, for our judges, we have to have a strong process for holding judges accountable for misconduct that at the same time protects independence and enables us to remove those that are acting contrary to judicial office. And finally, and possibly most importantly for independence, the system of governance by which the judiciary is run and administered is so crucial to dealing with things like resourcing and budget. So if we don't get those three right, then we're going to continue to be facing these challenges. And that would be my concluding remark. Thank you.
Well, thank you. I hope Prof, you want to say something in 30 seconds before we close off? Just 30 seconds.
Okay. Mine is simple. Stronger democracy, stronger judiciary. If we consolidate our democracy, our judiciary will be better. Reduce personnel rule. Keep engaging with the fathers we have as presidents and get them to understand why they should concede power as determined by the government. Thank you.
Thank you so much. Unfortunately, we could not answer many or most of the questions still remaining in the chat box more so, but also in the Q&A. But I hope people can find you online if you have Twitter or social media platforms so that they can follow up with the questions. But again, I want to thank you for taking the time to come, Professor Gabriel Arishe from the University of Benin and Chris Oxtoby from South Africa. Thank you for joining us, and thanks to everybody for tuning in. We will see you next month.
Thank you.
Bye-bye.